So we've had a couple of great panels already today. What we're going to do now in this third panel is we're going to shift a little bit at least and focus on the role of manipulated content of deepfakes in targeting certain populations, and then we'll hopefully by the end talk a little bit about some possible solutions, what the right mix of solutions are, some of which were teed up for us by the last panel, but I know that some of our panelists have a lot to say about. So I'm just going to introduce each of them very quickly, and then I'm going to ask each of them to spend three to 5 minutes or so setting up kind of whatever they'd like to react to or things they'd like to talk about. And then I have a series of questions we'll do just as we did in the others, open it up to questions from the audience at the end. First, to my right is Sam Gregory. Sam is a program director for Witness, an organization dedicated to helping people anywhere use video and technology to protect and defend human rights. He's an award-winning technologist, media maker, and advocate who from 2010 to 18 taught the first graduate-level course at Harvard on harnessing the power of new visual and participatory technologies for human rights change, and is currently the co-chair of the partnership on AI's expert group on social and societal influence on the Technology Advisory Board of the International Criminal Court. That's quite a long phrase there. For the past 18 months, he's focused his work on emerging threats at the intersection of AI, media manipulation, and rising authoritarianism, obviously making him a perfect fit for our event today, with a particular focus on how to prepare better for deepfakes and synthetic media. Then there's Danielle Citron, who I identified for you a little earlier. Danielle's a 2019 MacArthur Fellow and a professor of law at Boston University School of Law, where she teaches privacy, free speech, and civil procedure. She serves as the vice president of the Cyber Civil Rights Initiative, a nonprofit devoted to the protection of civil rights and liberties in the digital age. She also serves on Twitter's Trust and Safety Council and Facebook's Non-Consensual Intimate Imagery Task Force. She works closely with lawmakers and law enforcement officials and has testified before the House Intelligence Committee and testified just 2 days ago, right, in fact, in the House, on the challenges of misinformation and deepfakes. And then last but not least, Marianne Franks. Marianne is a professor of law and Dean's Distinguished Scholar at the University of Miami, where she teaches criminal law, criminal procedure, First Amendment law, Second Amendment law, family law and policy, and technology law. And I want to say, as a former associate dean, that list made me really happy. You basically teach the whole curriculum at the law school. Franks also is an affiliated faculty member at the university's Department of Philosophy and serves as president and legislative and technology policy director at the Cyber Civil Rights Initiative, the same nonprofit organization that's dedicated to combating online abuse and discrimination. In 2013, Marianne drafted the first model criminal statute on non-consensual pornography, usually referred to as revenge porn, that has served as a template for many states and for pending federal legislation. She regularly advises legislators and tech industry leaders, including Google, Facebook, Twitter, and Microsoft, a few that you've heard of, on issues relating to online privacy, extortion, harassment, and threats. So I'm going to turn it over and let Sam, you go ahead and go first.
Thank you, Mark. And first off, an apology. I've asked Patrick to whistle if I start to doze off in the panel. This is not an offense to anyone. I just flew overnight from Brazil, and I'm sustaining myself on coffee. So please whistle if you see my eyes moving in the wrong way. I want to raise 4 points to launch off. But first, I want to contextualize why, as a human rights group, we would be interested in this. And that's because I work for a human rights organization that cares about the integrity of more people being able to share their experiences from a grassroots level. We care about the nuanced version of what you might have heard Mark Zuckerberg trying to talk about yesterday in very broad brush, rather vague terms. I care about the value that comes out of many more people showing truthfully what happens at a grassroots level and how we protect them, ensure they're trusted. And so inevitably, when we go into the deepfakes discussion, I think about harms that will occur to a vastly greater number of people who are trying to share their reality and are facing already a rhetoric that says you're not truthful and will now face a technical barrier that will be used against them. So the 4 points I want to raise, and I'll just raise them as sort of top line and then hope we can go into them as well in conversation. The first is that we should view deepfakes as an evolution of harms, as an evolution of problems, not as this grand rupture. And we've talked a little bit about that in earlier panels. But I look at the past decade of widespread misinformation, visual misinformation that has exactly paralleled the spread of trustworthy information in war zones like Syria, against black activists here in the US and other people confronting power. And the lesson I take from that, and Mark referenced a little bit, like the way we've been approaching it at Witness is we have to prepare better, and we should know that we have lessons to build on to prepare better. We know that there are already existing harms that are being exacerbated, and there are existing learnings and experience we should be building on, rather than treating this as an ex nihilo problem. The second is, who do we center in those solutions? And I always worry when I come to DC because I know where we're going to center when we come to DC. We're going to center broadly in the US and probably broadly on politics. And the reason I was in Brazil was to focus, as part of a process we've been doing there of listening to civic activists and journalists and fact checkers in a country that has some similarities to the US, but many differences, but will be dramatically impacted by any choices that companies in Silicon Valley or legislatures in Washington or Brussels make that will impact them, a country of many hundreds of millions of people. And so I think as we think about who we center in solutions, I want to center two groups. One is clearly people who are harmed already by this type of tool. And of course, Marianne and Danielle know this far better than me, but women attacked by gender-based violence online. But we experience it in my world as journalists and human rights defenders attacked with those tools. And then I want to center the rest of the world as a group that is marginalized in this discussion. The third area I want to highlight is how do we ground technical solutions in socio-political realities. And so we've talked in the previous panels about detection, and we've talked about provenance. And those are, in some sense, technical questions, right? How do you get a great detection score? Or how do you certify provenance? But they land in socio-political realities. So is a detection system, and Sanam raised this, is it going to be accessible to people? Is it going to be explainable? That was one of the biggest concerns in a report we released yesterday in Brazil from journalists. We're like, is this tool going to be for me? Or is it going to be for Facebook and the New York Times? And so those questions are very political, and they tie into the suspicions people already have about the information ecosystem, that Facebook's going to husband its resources, it's going to give us another black box and tell us it's made a decision, or maybe the US government is going to do that. So thinking about how a detection system lands in a socio-political reality. And similarly, authentication systems. If we start to demand provenance, Matt gave a kind of sort of light version of this, which is, someone in the Middle East who has an old phone. I think about a dissident who doesn't want to add this information to be trusted because they don't trust their government, they don't trust platforms. This may not be a well-founded fear technically, but it's a well-founded fear in your heart. And so how do we think about who gets included and excluded as we make tech infrastructure choices? And the final, just to go back to it, how do we ground US decisions that we made, including legislative ones, in their global implications? And so I look forward, I think we'll talk about content moderation on this panel. In the world I work in, content moderation has often been used to take down human rights accounts, to take down war crimes footage, because the platforms are under pressure to use greater automation, to use greater discretion in taking down content. And so we have to really think, as we look at content moderation, how do we do that in a way that balances addressing real harms from something like deepfakes, but the way that that will also be used by authoritarian governments like Duterte and Bolsonaro to say deceptive videos are actually what we might call an edited video or a piece of advocacy confronting them, et cetera, et cetera. So let me stop there. And, yeah.
I'm just moving this ever slightly. So first, I just wanted to start by thanking our admired and wonderful colleague, Mark McKenna, for bringing us all together, and thank you, Notre Dame, too. And most especially, this is a thrill for me because I'm the vice president of the Cyber Civil Rights Initiative, and I get to sit next to my president, Marianne. So this is amazing. Any opportunity to sit on a panel with Marianne is like, I'm there, I don't care where I am, so I'm coming. In thinking about these technologies and how we use and abuse and exploit them. 10 years ago, if you told Marianne and I that we would be having a conversation here with a group of people who would take the misuse of technologies against women and marginalized people seriously, we were fighting for that, but it was like screaming into the dark. And so it is sort of so incredibly gratifying feeling like we've put gender on the table, it's here, people's vulnerabilities and their membership in subordinated groups, we're here, we're seeing it in a way that is incredibly gratifying. About a year and a half, maybe it was 2 years ago, Bobby Chesney and I, he's a national security guru and I'm a privacy and civil rights and speech person, decided to sort of team up and write about deep fakes. And what drew me to the project was a story about how Reddit had recently taken down a subreddit devoted to deepfake sex videos. And before they took it down, it was obvious from the discussions, not only were we seeing the insertion of female celebrities' faces into porn movies, but the desire from the comments was clear that people wanted to create deepfake sex videos of their ex-girlfriend, of a woman they went to high school with who paid no attention to them. And the question was, how many photos do we need to make these? And when Bobby and I banded together and wrote a series of articles together, we imagined all of the ways in which national security is potentially imperiled, of course, trust and democracy. And we began, though, with the individual harms and the exploitation of deepfake videos to exploit individuals, harm them, as well as vis-a-vis sort of business sabotage and companies. And where we've seen the threat really realized in empirically shown ways is the deepfake sex videos. So Deep Trace Labs just came out with a report showing that 8 out of 10 porn sites have deepfake sex videos, and that there are 4 sites whose business model, advertising model, is deepfake sex videos. And we're going to talk a bit later on about why there are business incentives and without any barriers to creating a business model around abuse, thanks to a federal law, which we're going to clearly talk about today. But it is no surprise, right? Marianne and I have been closely watching ways in which we, whatever the technology is du jour, using it, exploiting it to undermine the life opportunities, especially of women and minorities. And so I know I'm only supposed to be 3 minutes, so I'm going to try to wrap this up. But this is a front line in which people's lives are being sort of decimated. When a Google search of your name has a deepfake sex video in it, it's fundamentally, I would argue, an invasion of sexual privacy. It's the exploitation of your sexual identity, even though it's not your body, right? It's someone else's. But your ability to control and determine how your sexual identity is portrayed is undermined. It's snatched away from you. And your dignity is entirely decimated. You're only just, right, a sexual object. You're really not, you're sort of a partial identity. And fundamentally, it undermines equality. We've seen it not only increasingly affect, 99% of all deepfake sex videos on the 4 sites and the 8 out of 10 porn sites are all women. So 99%. So this is clearly a gendered problem. And it can hijack your life opportunities, your ability to work, to get a job, keep a job, to speak and engage, to feel safe. So I'm grateful, though, that we are having a conversation in which it's clear, like, I don't have to convince you, right, that this is a gendered problem in a way that 10 years ago, when I would talk about cyber gender harassment, Mary and I would look at each other and say, no one's going to buy what we're saying. So it is with deep appreciation that we seem to be in a shared spirit of understandings. So thanks.
Thanks very much, and I want to underscore, some of the points that have already been made by Sam and Danielle about vulnerable populations being the first ones who are targeted by any product or service that's going to be misused. We should think about women in particular as an early warning system. And if we had thought about it like this before, we wouldn't be in the situation we're in now. So I think one of the things that we have to do when we're diagnosing our current moment is to say we wouldn't be here and we wouldn't be so late to the solutions if we cared when these kinds of things happen to women first. So I think that's one lesson we have to take away from this, and that if we're going to come up with solutions from here on out, we do need to center the experiences of those who have been most affected. And I also think that we need to make sure, and this is something, again, that Sam had also referenced, this is not, and other people this morning have referenced, that this is not a brand new problem. Deepfakes are very sophisticated. They are the kinds of things that we're going to have a hard time distinguishing from falsity, but it's not just a question of the sophisticated fakes, it's the question of completely unsophisticated fakes that people are going to want to believe because we're living in a political moment where people want to believe what they want to believe. So the Nancy Pelosi video is not sophisticated, but it's something that people want to believe. The Pizzagate conspiracy is definitely not sophisticated, but people wanted to believe it. So if we're going to get a handle on the problem of deep fakes, first of all, I think we should move away from the term and maybe replace it with a term that Danielle and I have started to use in thinking about legislative solutions, which is digital forgery. To stop thinking about it as a deep fake because it makes it sound like the crisis of the day, and it gives way too much power to the person who started all of this with his application on Reddit. So I think that we don't really want to give that kind of credit to this person. And we want to think about the ways in which this problem of digital forgeries is different from, but also very similar to other kinds of misinformation, what the motivations are for people to embrace false information, to think about this in terms of propaganda, to think of this about how for centuries we've had anti-Semitic propaganda, we've had the protocols of the elders of Zion, or if you think about the witch hunts, the literal ones, not the ones that are made up today, but the real witch hunts where we made up ideas about women and their power. Think about how those have been effective throughout history and why. In other words, the problem with digital forgeries and deepfakes is that we are eroding our will to truth and replacing it with a will to power. That's it in a nutshell. And if we think about it in this way, it isn't just that we're talking about privacy or security or safety, we're also talking about speech versus speech. So no matter what Mark Zuckerberg tells you, free speech doesn't just mean not regulating the bad stuff, because if you have an environment in which you reward false information, you reward this kind of postmodern reality that says believe whatever you want to believe, you're going to lose out on speech, not just on security, not just out on all these other things, but people's voices will be silenced when that happens, and it will usually be women, other marginalized communities. So it is always a speech versus speech question, and anytime someone makes a claim on behalf of the First Amendment or the free speech principles, we always have to ask, free speech for whom, who's winning, who's losing? Which is the last thing that I'd want to say in terms of framing this problem, which is who's responsible for this? Now, obviously, the people who are responsible for some of these digital forgeries are the people who are making them, the person who decides that he's going to take the software and release it to the public and make it easy for anyone to make a request to get their ex-girlfriend to appear like she's naked. But I think we need to say in much stronger terms, even than the last panel, that the responsibility here really does lie with these platforms. They are exploiting this particular toxic kind of content. That is to say, Facebook is responsible, Twitter is responsible, Reddit is responsible. And we can't keep acting as though they are simply innocent bystanders who are saying, well, you know, it's all speech. It is not. And ever since the very beginning, all of these companies have had pretty strict rules about the things they don't like on their platforms, including things like spam, which is not a stable category, as we very well know. So this idea suddenly that every time we don't want to regulate, we're going to invoke the First Amendment or free speech is bogus, and we should make sure that we're not buying into it, right? So I think one of the things that we have to have as part of our conversation about legislative or other types of remedies is actual incentives being placed on these companies that, as the last panel referenced, Jessica in particular referenced, there's no particular reason for us to have this approach to this industry uniquely, to tell the entire tech industry, unlike any other industry except possibly the firearms industry, we're going to tell you, you have no responsibility for the terrible, terrible consequences that will result from the reckless promotion of your products. We have to take that immunity away. Now, when I say that, that doesn't mean necessarily for all of you Section 230 experts in the room that we have to get rid of Section 230, but it almost certainly means that we have to rethink how we've interpreted it and possibly try to clarify it, because it doesn't make sense for us to try to say that we're living in some kind of free speech utopia. We are living in the world that Facebook made. This is it. So if we think that we're better off than we were 20 years ago with regard to truth or autonomy or democracy, then congratulations. But I suspect that many people in this room are thinking, no, actually we have fallen into a certain kind of pit, and we're not going to get out of that pit until we start actually putting some pressure on the powerful actors that are making money off of the very degraded information ecosystem that we have right now.
As you can see, we invited everybody on this panel because they don't really have any views that they would like to share. So the place I want to pick up, because it's a common thread in a bunch of the comments, and it even goes all the way back to this morning, because we heard many of the folks on the technology panel this morning talking about ways in which this was not a new problem, right? That some of the tools are old. Obviously, some of the harms we've been talking about are old, and several of you talked about, you know, the ways maybe we could have paid attention to this before. So I guess I want to phrase the question in the form of, what are the lessons we should have learned in terms of the ways that we might have approached this that might have prevented some of the situation we're in now? So I mean that conceptually, but also like, what steps did we miss that we could have taken that might have prevented some of this?
I'm happy to go. So for instance, just to take a specific example, back in the 1990s when internet browsers started to support imagery, one of the first things that happened was porn sites, of course. They were at the cutting edge. And many of these porn sites would take celebrities' faces and they'd crudely Photoshop them onto these porn sites. That was something that everybody knew was happening, and yet nobody cared about it. So as long as it was entertainment and as long as it was women's bodies, we didn't care. If we'd had a real legislative response then, if perhaps someone who was passing the Communications Decency Act at that point might have said, you know, we might need to think about the worst uses of this. And recognizing, of course, that the Section 230 of the Communications Decency Act was meant to be a more reasonable way of trying to think about the powers and the problems of the internet, because there was a hysterical overcorrecting response on the part of Congress freaking out about porn and kids specifically. But not importantly, anybody in Congress thinking about the actual harms being done to women. We're talking about child exploitation, we're talking about women, and about whether or not there was going to be something dark, much more dark, coming if we were simply going to sit back and let this sort of thing happen and let women's bodies and faces be used in ways that they had never consented to being used. If at that point we'd taken a step back to say the internet's going to be this incredibly powerful tool for presenting people as if they had done things and said things that they hadn't, we might have gotten a handle on this. We might have wanted to rethink whether or not we want to hand, in 1996, the industry basically a blank check and say, do whatever you want. I'm sure you're going to regulate it in the way that's going to be most beneficial for the general welfare.
I'm just gonna hop into, I think, affirm what prior panels, we build things and we often don't think about the end uses. And that tends to be, we have this incredible optimism about how these tools are gonna be used. So when I first was talking about some of my work on cyber harassment, I wanna say 2008, I presented in a room full of computer scientists who were had been at Bell Labs and had helped build ARPANET. And when I explained all these terrible uses of these, ways in which we were tormenting individuals online, they came up to me afterwards and said, we wouldn't have built it the way we had built it had we realized that this was how it was going to be misused. And so your question, Mark, was, conceptually, themes of lessons of the past is we have to think really carefully about the ethics behind building things. And we tend not to. We rush, we adopt, whether it's fusion centers, whatever the technology is, and we just don't think about it, and we need to.
So I'm going to echo some of those. I was recently introduced to something called Collingridge's Dilemma, which may be incredibly familiar to people already, but it's basically, it's a dilemma around technology where when you are first experimenting with technology, you don't have information on its impacts, if it'll be widely shared, and then of course, once it's widely available, you have a power problem that's very hard to change the infrastructure around it. As I look at that dilemma, I think parts of it are true, but we actually do have information on the harms now. And so I'm going to take a slightly more positivist view on where we could be now, which is that there is still space to do better now. And I look at this from the lens of seeing how badly major companies did around something like Myanmar and hate speech. Just horrendous accountability issues there in terms of platforms not responding to civil society saying you're causing direct harms on the ground, you're contributing to a genocide. If we look at that as the previous pattern, we should be saying, what can we be doing now that is ensuring the voices we're describing here on this panel are clearly there in terms of how the platforms respond, are clearly there in terms of how legislators respond. And I do think that's a positive opportunity in the sense that there is a major scope to the deepfakes problem now, but what we've also noted is it's not as big as some people think it is, at least on a global scale, And once we step outside of gender-based violence, and that's not to indicate that gender-based violence is not a problem, it's simply to note that the scale of people's perception of it is greater than the reality, and there is a space to be engaging on this in a way that really reflects a lot of voices. And I think at the moment that is about listening to people who have direct experience with gender-based violence, listening to communities around the world, and it's also trying to come up with a lot of partial solutions. I think tech's instinct for this, and perhaps legislators, is to go for big silver bullets, and big silver bullets won't work here. One thing I put on the table before is we have a set of like 12 recommendations we use to guide us, and they're all partial solutions. And I think resisting the temptation to silver bullets, but listening really closely to a lot of different people who are going to push for different elements of the pie is really critical now.
So, since we've already got content moderation out on the table here, I think we might as well just sort of go in that direction. So one of the things that maybe actually I want to kind of connect it to a slightly bigger conversation, which is like, what's the right mix of responses, right? So some people on the panels were talking about there's certain kinds of technical solutions that, we could employ here. Some of these are cultural solutions, like, I can't remember if it was Finland. I just read a story about an entire curriculum they basically built about teaching people to be critical consumers of information online. We don't really do that at all in our country. So what's the right mix of sort of cultural, sociological responses, technical solutions, legal solutions? I assume the answer is that there's a role for all of those, but I'm just kind of curious, like, how you all see the interaction of those things. What can legal tools do, and what can't they do, and where are the roles for other things?
So at the Cyber Civil Rights Initiative, for which Danielle and I both work, our goal essentially is to try to take a three-pronged approach to problems that are facilitated by technology. And that's a legislative approach, and there's a policy approach, and there's a social approach, a tech approach. So we think about it in terms of where are the gaps in the law? Where are there genuine issues that we do need to think about harms in a new way, right? Are there certain types of harms that are actually not the kinds of things we've seen before, and to the extent that that's the case, we need legislative reforms, what we've done with the non-consensual pornography issue. And then we think about the policy solutions or the sort of social solutions as, how do you really try to diagnose and try to intervene against the impulses that are driving people towards these really malicious acts? Because we can't really keep telling ourselves that there's just these problems and we need to figure out how to solve them without trying to understand, why do people want to do this to other people? And why is it that certain groups are always the ones that are most likely to be targeted? These are not sort of equal opportunity harms. People are not being equally targeted by deepfakes or other types of technology-facilitated abuse. So we need to think about what the underlying motivations for that happen to be. And that leads into the question about technology, the role that tech companies need to be playing in all of these sort of realms is that, of course, tech solutions, design solutions, could do more in a day than a law can do in 10 years. So when Google makes finally the right choice to say we're no longer, or at least we're going to allow people to say, take down those non-consensual pornography results out of the Google's index. They finally did that. It took them a long time to come to that conclusion. Facebook also bans non-consensual pornography now, as does Twitter and the other major players. But what we really needed from them was that kind of response, because whether or not we get a good law on the books about this, and we're up to some good laws on the books about this, but we're still far from the ideal. When Google says it's going to be no longer searchable, that's a massive impact that company can have that no law is actually going to be able to have. And that's the kind of thing we need companies to do. That being said, the reason why we can have them do that is because, well, the reason why we have to resort to that is because there are no real incentives to make them do anything. And so we have to throw ourselves at the mercy of these companies and hope that they do the right thing. And every now and again they will, if the PR situation gets bad enough for them to do so. But that can't possibly be enough, right? No matter how much we're being told by industry representatives, oh, don't tinker with our immunity, don't tinker with Section 230, because that will mean that we can't take this stuff down and we can't do these innovative things. That's a lie. They're lying to you, right? They sat next to Danielle in this hearing 2 days ago, and you had representatives from the industry say, if it weren't for Section 230, we could not do the kind of work of taking down bad material, which is false. The First Amendment lets them do exactly that, and it's pretty robust when it comes to that. So we've got a really complicated situation here where the industry is not only able to engage in incredibly predatory practices that other industries couldn't get away with, but they're able to constitutionalize all of that and say, we're doing this on behalf of the First Amendment, we're doing it for you, so that you can all enjoy freedom of speech the way you have been. So I think we really need to start thinking about how we have to call the industry to account and stop believing it when it tries to try to sell us this bill of goods that's saying, however painful and awful it may be for you, your life is destroyed and you can't get a job and you can no longer maintain intimate relationships and you're basically ruined, but really we're all just enjoying free speech now. We have to stop letting them say that. So I think that, I don't know if there's a magical mix, but all of those things have to be part of the solution. We have to talk about the ways that law can play a role, but we also have to talk about the responsibility of tech industries to do the right thing. And we have to get at people's motivations for why they hate women so much and why they hate people of color so much, that these are the kinds of things that we're going to use great innovative technology for, to do these terrible, terrible things to people who are already marginalized.
Do you want me to talk about 230?
Sure.
And I also just want to say, we shouldn't discount, so I'm going to embarrass Marianne just for a quick second. So in 2014, you'll forgive me, right? Maybe?
Depends on what you're about to say.
Okay, so oops, I can't pre-screen here, right? But in 2014, when we first wrote the very first article on criminalizing revenge porn, what we called it then and now call it non-consensual pornography, there were 3 states that criminalized the practice. And thanks to literally the most tireless advocacy of Marianne, state for state, right? Testimony for testimony, house for house. There are now 46 states, right? DC that now have laws criminalizing the practice. They're not perfect. They didn't always listen to Marianne, right? Sometimes out of committee comes a bill that, you're like, oh, goodness gracious, they didn't listen to me. But it's seismic change in 5 years. So, and law is our teacher. It is true that imperfectly enforced, imperfectly drafted, and we've got this federal bill proposed, which hopefully, and has lots of bipartisan support, but law's our teacher. And so there is a deep value in passing it, even if by catch can, they're enforced. Section 230. Section 230, of course, has been it's been a valuable part of creating a landscape in which we have vibrant social interactions. At the same time, it has been, in some sense, a free pass for companies to, especially the worst of the worst players, ignore abuse and illegality, and often not just being reckless, but encouraging and making your business abuse and illegality. And so while we have seen some, I would describe as good faith efforts responding to CCRI's call, such as Google de-indexing and searching of people's names, non-consensual pornography, we have sites whose literally their reason for being, their ability to make money, is abuse. And so one way to think about how we might amend Section 230 is not to get rid of it, to keep it, but to bring it back to its original purpose, which was to incentivize what then Congress called good Samaritans, essentially cleaning up the internet under and over-filtering speech. But in order to enjoy the immunity, it should be conditioned on what Ben Wittes and I have called reasonable content moderation practices writ large, not with regard to any particular speech that's being litigated. And so we could take a more narrow approach, but that's one possibility, because otherwise you've got market pressure that you can bring to bear against Google and others we've seen, at least in part, Twitter and Facebook, but there are actors who market pressure is like the joy that they can say, sue me, sue me, go ahead. Revenge porn will live on my site, Deepfakes X videos, because they get to say, sue me, haha, right? So I think we're in a moment of reconsideration for 230.
So maybe I'll just share what we heard in Brazil, so to give maybe a different perspective on what people wanted as a mix of responses. And this is probably representative of other places as well, but I just want to use it as a non-US example. So people did emphasize media literacy, but they said in the absence of technical signals, we're not going to be able to make good decisions. So what I mean by that is expecting people to spot a deepfake is a terrible idea, right? They're not going to be able to do it, particularly the more subtle manipulations. It puts a terrible onus on individuals. They were like, we need to invest in broader media literacy, particularly for populations who are already vulnerable. So in Brazil, that is favela residents, people of color, black Afro-Brazilians. There are analogs in the US, that are communities who are targeted by disinformation particularly. So invest in media literacy, make sure the platforms provide signals that can help people, but make sure that that's embedded in media literacy. That was one thing. The second thing they said is we need available tools. As I said, there's a deep suspicion that the tools that are developed will not be available to people globally, will not be available to ordinary people. And Sonam raised very significant questions about why that is challenging, right? The adversarial nature of it. Those don't mean much to ordinary people. They go, no, you're just keeping that tool from me, right? So just when someone says it's an adversarial problem, people are going to game it, that doesn't really work when you're actually talking to ordinary people who are saying, why are you not making this available in a way that I can use it? And they talked about what platforms need to do better, right? Clearly, and the question of lack of platform control over WhatsApp, the lack of ability to see how things flow, to have the data to understand how misinformation flows, right? We know it's not the content item, it's how information flows. It's who sent it, it's how widely it's shared, and that's really hard to know if you're a fact checker or an ordinary person. So in the absence of that information, you're tying people's hands behind their backs, and you're also tying people's hands behind their backs around existing forms of misinformation. So people talk about what we might call shallow fakes, like these miscontextualized videos. There are still not good tools available publicly for what Sonam described as similarity search or reverse video search, the ability just to see that a video is actually from 10 years ago. So people also are pointing out we've got to solve for existing problems, not just future problems. Content moderation, I just want to say 1 minute on that, and I'm not an expert, obviously, in the same way that Danielle is. I think we, within the witness context, have seen quite significant challenges about how companies respond to content moderation regulation. This is not to say that regulation is not a good thing, it's to say, what does it drive the incentives? And the incentives we've seen around automated filtering, around content regulation, lead to the takedowns of a lot of human rights speech and a lot of human rights evidence globally, because companies take shortcuts and they use algorithmic and AI-based automated solutions. So if we're going to propose regulation in this space that tries to establish this, we also need to make sure there are incentives to make sure they don't use the tools that lead to the loss of speech we do care about, as opposed to speech that we believe is harmful on platforms. So just want to note that. I think that's a complicating factor that comes up also around deepfakes, because deepfakes could also be satire. They could be reframed as critiques. It might be actually a harmful deepfake reframed as a critique and shared to explain something. A whole bunch of things that are very hard to spot with AI.
May I say one thing about the law that we now have on the books? In Section 230, we actually have a provision in the Decency Act which would provide that incentive to not over-filter, which is Section 230C2, which says if you're gonna filter too much, you've got to do it in good faith. It's an underused sort of portion of the law, but it's certainly anticipated by Congress in 1996. We also might consider thinking about a federal anti-SLAPP law, but Congress anticipated this problem, so it's not as if there aren't ways. I'm not trivializing it at all, right? But it's so important that we're going to use automation to take down usually the most marginalized, talking about, let's say, for example, hate speech they've experienced. That's how we've seen the hate speech ban sort of turn out in the United States. Like Sean King is kicked off of Facebook talking about the hate speech he's received rather than the neo-Nazis. But nonetheless, law kind of anticipates some of that, concerns about over-filtering.
I'm sure we have some questions in the audience. Yeah, Paul.
Danielle, do you worry about the impact of the tool you want to create when Facebook has to face a jury in Whitefish, Montana, deciding whether Facebook should have taken down the nasty things that people in DC were saying about the Patriot Party?
Okay, so, and you, by the tool, you mean amending Section 230, right?
Potential for liability.
Right. Yeah. If we bring common law to bear into this space.
Similarly, if it's an administrative agency.
Right, which I wouldn't support, right.
The very candid admission we had yesterday about how elections have consequences. I know
Okay, so first let's say that common law has long operated, and that the notion that this is kind of if indeed we have a reset and say the typical common law rules that would be raised in a lawsuit, there's one myth is that you sue Facebook and there's automatic liability, strict liability, and that's not the case. You've got to prove a cause of action. If indeed there's defamation and involves a public person, you've got to show actual malice, or you're reckless as to the truth of the matter asserted, and any other theory you'd have to prove it. Just to be clear.
Has to decide at the time it gets notice of the claim whether it faces a realistic possibility of, number one, liability, or number two, having to spend money on defense.
And so the reason why Ben and I devised the change that we've proposed is that in what Facebook would face in a 12b6 motion to dismiss, or at the state level, an analogous motion, is to show that its content moderation practices, generally speaking, as to a specific type of content, are reasonable, not whether their decision vis-a-vis any particular speech of, let's say, Richard Spencer's mom in Montana on Facebook is reasonable. And so it does shift the focus. You can shake your head. I'm happy to talk about this with you afterwards. We can talk about how those pleading rules would operate, but I think the notion that Facebook is, let's think about it this way. At the turn of the century, we had something called the fellow servant rule, which immunized from responsibility, essentially, burgeoning industry that was, its workers were vulnerable to having their hands and their, their bodies broken and decimated. And the liability rules were such that we protected industry from liability, in part because we wanted to ensure that they got off the ground. And over time, those liability laws shifted away from blaming workers who couldn't certainly control their environments to putting the liability with the least cost avoider, which was the industry. Right, and we're in this sort of same spot here. For the past 25 years, we've essentially been in fellow servant land with the Communications Decency Act, in which platforms have been immune from responsibility and protected from liability for user-generated content that's externalizing profound harm. And of course, that includes new entrants and the behemoths of today who would face responsibility. But I think the time is now. It's clear the results are in. It's been massive devastation, right, to individuals who are the vulnerable ones, who are chased offline and who are silenced, and whose the speech calculus and equality calculus is pretty clear that there's deep and severe costs with this immunity.
Yeah, in the back.
Hello?
Okay.
Hi, thank you. With Section 230, we saw issues with 8chan and the heinous things you've seen on there, and people talked about it. But we also saw a business response to it. Cloudflare, I believe, dropped them so they couldn't find host servers. Do we really need to change Section 230, or should we push for more of these, industry approaches and incentivize and promote these as good actors and good responses in this debate?
You should. Yeah, I think Marianne. Also, everyone buy Marianne's "The Cult of the Constitution." It's a brilliant book. Just saying. Okay. See, I'm allowed. Come on. Okay.
Doing my promotion for me. I love it. Love it. That's why we're friends. So, but the two things that you just mentioned really go hand in hand. Yes, we do want to incentivize industry, but how do you incentivize them if you don't have any legal hook, right? It's to say, we really want you, industry, to do better. But if you don't, you're still going to get this absolute immunity against any possible litigation. And then we wonder why it doesn't work. Why did Cloudflare wait so long? Cloudflare is one of the reasons why white supremacist sites were able to flourish to begin with. We've been living in a world where they took no responsibility and took a so-called First Amendment stance, which, by the way, makes no sense. Private entities don't have First Amendment obligations. What they have is First Amendment rights not to carry or promote any kind of material they don't want to. And that's something we need to keep thinking. That is a very, very powerful force. Private entities, and even if we had any doubts about this, very recently, just a few months ago, in the decision called Halleck, the Supreme Court reiterates private entities have basically all the power they want to take down whatever they want. So they don't need any extra protections for that. Now, does that mean that they might get sued every now and again, and it might actually mean that they have to wind their way through the courts? Yes, and that's what every industry has to deal with, and we're pretty certain at this point that the tech industry can probably take it. Right? We're not talking about some, the analogy used to be the infant that might get smothered in the cradle. I mean, that is not what we're dealing with now. And so if we're actually going to be realistic about these possibilities, think about the fact that Section 230 is only one of the ways in which you get preemptive immunity. It's basically stand your ground for the internet, right? It's not a question of you don't have any other defenses. You still would. You'd still be able to say, it's not my responsibility, or for any number of reasons, I can't be held accountable. But the reason why we're in the state we are right now is because of the moral hazard that's created by Section 230's overzealous interpretation and application by the courts, which says do nothing, or even, in fact, pocket all the profits from this really bad behavior. Get all those eyeballs, get all that kind of revenue from this terrible behavior, and nothing will happen to you. We will protect you from suits, and then we wonder why 20 years down the line we've got the industry that we do.
Yeah, thank you.
So as we talk about these platforms, so I'm wondering, so we have these messaging apps, say WhatsApp, right? For example, it's encrypted. And so who has the liability on that? Is it my phone? Is it the app creator? Is it the medium where the messages are being sent and shared by individuals? And that's a lot of misinformation, and these deep fakes are floating through these messaging platforms. How are they to be looked at? Are they governed by the Section 230, or are they different? But then who has the liability on that?
You're governed by Section 230.
So do you mean liability for bad actions that are
Yeah.
conducted through these services?
Yes.
Right, well, so it depends, right? So I don't know if you're asking a legal question or a moral one, because
Both.
turns out the answers are pushing in different directions. So the legal answer, right, for a very broad swath of intermediaries, let's just call them that, forget about the technical legal language, but the intermediaries that are providing essentially a platform for user-generated content, right? So that you're not going to hold the platform responsible for what users are doing. That's basically what Section 230 does in a nutshell, with the exception of federal criminal violations and intellectual property violations. So Section 230 is incredibly broad because it essentially says Facebook has no responsibility if someone misuses or uses WhatsApp in a really troubling sort of way. Now, as an answer to maybe the moral question, or how this works in any other context, again, outside of the firearms industry, would be there's a thing called collective responsibility. So I wrote about this recently in the New York Times about how we do in every other context outside of the tech industry and the firearms industry, we think about the fact that people can have contributory sort of responsibility for something. That is, imagine, for instance, you have a hotel that doesn't provide adequate security measures for a gunman who, over the course of a few days, brings 22 suitcases up to his room so that he's able to commit the deadliest mass shooting in U.S. history at the Mandalay Bay. So MGM just paid out in that, and they have agreed in some sense that they're responsible, right? There wasn't a legal finding, but they settled. And there's a recognition there that, of course, MGM is not the shooter. They're not the person who actually killed those people, but there's a sense in which they fell down on the job. And that's true in the offline context repeatedly. And what the internet has done to us morally and legally is told us, forget about collective responsibility. We're going to really narrow the concept of liability to the person who pulls the trigger and no one else. Everybody else is off the hook. And we get exactly what you might expect with that. No one is taking care of anything except for the things that they actually literally did. And that's encouraging all of us, not just legally, but every day in the decisions we make, to say, well, I can contribute to this online mob because I'm not actually the person doing the terrible thing. When that person finally commits suicide, it's not my fault. There's all these multiple things that I can lose myself in. So I think that's exactly why that reading of Section 230 is so wrong. It's because it goes against all of our subtle legal expectations about behavior, and it really sets up a very strange dichotomy between any offline business and any online business. Offline businesses, brick and mortar stores, would have responsibilities for things like contributing to criminal activity, whereas all you have to do is move your business online and suddenly you don't have any of those same responsibilities.
But how do you govern collective responsibility, especially in the online medium where creators of this content could be anywhere in the world, governed by different moral values, governed by different cultural aspects, and the information flows.
Sure.
Now, in the United States, there's Section 230. It may not be in Europe, there's GDPR, but it may not be the case in other countries. So how do we regulate this collective responsibility when information has no boundaries?
So law can be, I mean, law has boundaries, and the internet certainly has boundaries, an insight that Tim Wu and Jack Goldsmith made, I would say, over 10 or 15 years ago. So we can bring law to bear and if you have jurisdiction over these actors. But the notion that it's not so diffuse, so law in the tort context has a doctrine called negligent enablement of criminal activity that has contours, that is not going to be successful in every case, but just as we think of the hotelier, we think of landlords and tenants. If they don't maintain the safety of their buildings, then they can be held also responsible in tort for negligence. And so if you can get jurisdiction over the actors, and you're right, that's a challenge, right? If you have the incentive to find them, if they remotely have a deep pocket. Right now, there just aren't deep pockets. And so you may have a cyber mob, or individuals distributed widely all across, the world sharing content. No one person, is responsible for the entirety of the harm. It's like 1,000 bee stings. And then you, don't have jurisdiction in the United States over these individuals, and they're not worth suing even if you did. And so that's why, thinking about collective responsibility and the platforms, because they're in many respects the least cost avoider, because they're in control of all of this. And so that's why I think focusing on the platforms at least has to be part of the calculus. To go back to Mark's initial question about how we think about the set of tools we have on hand.
I want to go back actually to your initial question, which was around messaging apps, because I think they get under-discussed in the US because we don't use them as much as globally. And again, going back to Brazil, massive use of WhatsApp, a massive use of audio messages on WhatsApp, which we don't even think about here. Clear impact on the elections in 2018, recently documented yet again, right? So you have a massive problem there that there's not great visibility for the platforms into that space because of end-to-end encryption, and there are many reasons to defend end-to-end encryption, which we could obviously have a whole panel around as well, and the pros and cons of that. But if we assume we have end-to-end encryption, then that puts incredible onus on the platforms to be enabling individuals within the platform to be able to understand falsehood and the dynamics of falsehood within the platform, and people who are thinking systemically about the platform to understand the bigger dynamics of movement of information. And both of those are missing in WhatsApp. So if you're thinking very practically, you would look and say, why is it that an individual within WhatsApp in Brazil can't check if something is a falsehood, check out of WhatsApp, out of the encrypted environment, and why is it we don't have information on the size of groups, how it's being shared, that is available to the people who are also looking for people using this for misinformation and disinformation. So again, a lot of this is about what platforms should do in order to enable individuals and to enable also the intermediate layer of fact checkers, investigators, government, law enforcement to be better at dealing with this without necessarily compromising other values we might care about, like privacy.
Well, I think we did more than identify another panel. I think we just might have identified our next conference, right, which is on content moderation. I think you all heard them volunteer to be part of that as part of that. So anyway, we're out of time and we're going to have to wrap up, but I just want to reiterate thank you all for coming, all the panelists for being here. I think this was a really great start, and it was a really robust conversation and obviously a complicated problem that one morning isn't going to solve, but hopefully you can join us in some more conversations about it. So thank you all for being here. So.